I think we go. Did you see the countdown then, Chris?
Yes. Hello, everybody. The wonders of live TV. My name's Chris Hynes. I'm from Hynes Legal, and a very warm welcome, as always, to Frank Higginson. Frank.
Hello, everyone, again.
Happy Friday to all. Don't forget, first of all, like and share, please. Get the word out that we're doing Friday webinars every Friday, funnily enough, at 2 o'clock, and we're going to share our wealth of expertise. So get the message out that you can also register on our Facebook page for next week's events, and you can get reminders about that and pass that on as well. The more the merrier in this sort of thing, not just from our point of view, but for yours. The more people that participate, the better the chances are that you'll pick up a bit of information that's going to be relevant to you, frankly. Think about it, community management, group decisions, group input. Am I wrong, Frank? Or?
No, mate, you're 100% right. This is, and I suppose we're talking about the body corporate democracy today.
Oh yes.
Yes, which we've both seen lots of.
Yeah. So look, today's topic is what we're calling dysfunction in bodies corporate. Now, for those of you who don't know, though I can't imagine anybody doesn't know anymore, I used to be the commissioner for body corporate and community management. And the number of times people would come to my office and say, my body corporate's dysfunctional. It's a mess. Nothing can be done. It's probably at least every day, if not more so. But what does that actually mean? We're going to give that a go today. We're going to sort through what it means, what it doesn't mean, and then importantly, Frank, because we're solutions-focused people, what you can do about it.
Absolutely, which is more the point. You know what I mean? So, and I suppose there's no definition of dysfunction in the legislation, and I suppose this is one of the things that, community living, bodies corporates, volunteers, effectively low thresholds of corporate governance can lead to lots of conversations about this. So I know, and I suppose, Chris, when you were commissioner, when we get these sort of conversations, because people are generally unhappy with what's going on, which leads to the allegation of dysfunction, go ring the commissioner's office and have a chat with them, because they'll give you free advice about it. So probably some of those daily chats you were having were referrals from us at the time, because
which
people,
is fine.
which
is fine.
Absolutely.
Absolutely. Dysfunction, I've just done a quick dictionary search and I'll just read you out. So dysfunctional, not operating normally or properly, fair enough, or unable to deal adequately with normal social relations. I think that's probably more the definition we're after. So we're going to start in the negative this week. What is not dysfunctional? So if you say to us, my body corporate situation, my strata situation is dysfunctional, here's what it's not. It's not because you have a difference of opinion with your neighbours, your manager, or your caretaker. It's not because somebody spoke to you rudely at a general meeting. Frankly, it's not even because somebody abused you at a general meeting or on common property. It's not because you didn't get your motion approved. What else have we got, Frank? What else is it not?
Yeah, and I suppose the motion approval one's always interesting, because you do get occasionally the ones where there's a significant voting block, which might even be a single owner. So in corporations law, there's a thing called sort of oppression of the minority, where a majority shareholder might vote things in favour, and there's that might not necessarily be in the interest of the company as a whole. There's no equivalent statutory provision from a BCCM Act perspective, but there probably is scope in relation to whether a decision was reasonable in the circumstances. So it's not quite an oppression minority thing, but just because you didn't get your vote up absolutely doesn't make it dysfunctional. Not getting the information you're asking for, not having your demands answered, is not dysfunction on its own. Things not being done the way you think they should be does not necessarily mean dysfunction. And again, we've got this, in Queensland at least, this overriding statutory obligation to act reasonably. And again, that's where we as lawyers make our money, in the context of what is that. And what that is depends on individual circumstances at the time and what's going on. But just because it's not being done the way you like it or want it doesn't mean that it's dysfunctional. And I suppose the last but not least, which we, interestingly enough, the levy conversations are sort of dissipating a little bit That was peak COVID, I suppose, there at the tail end of it. But levies being high doesn't mean a body corporate's dysfunctional either.
And people, I can't pay my levies isn't dysfunctional, but levies not being paid collectively and not being collected, that may well be. Yes. So all those things we just listed off, they're annoyances, absolutely, and irritations and make life challenging, but they don't mean that the situation is dysfunctional. And even if you have a body corporate or a strata corporation that has a lot of disputes, that also doesn't necessarily make you dysfunctional. In fact, you could make the argument, couldn't you, Frank, that a healthy body corporate would have disputes because people would robustly be sharing their views.
And there are differences of opinion. Absolutely.
Yeah.
You know, and that's just life.
Yep.
I mean, we have differences of opinion from time to time.
No.
It's just we occasionally, but we ventilate them in a professional, respectful, and considered manner, as opposed to calling each other names. Absolutely.
So that doesn't make things dysfunctional. It might in some cases if the disputes are of a particular type, and we'll get into that in a minute. So as Frank said before, there's no definition of dysfunctional under body corporate legislation, but here are the things that we think would make your body corporate dysfunctional, or at least get close to it. The most obvious one to me, the bills not getting paid. So all of the body corporates' financial responsibilities not being met, that to me says it's dysfunctional. Another big one, your insurance isn't being paid. I mean, that's absolutely critical, and it literally can be a life and death situation. As I said before, levies not being struck at all and levies not being collected, that's probably means that your body corporate's in a real predicament.
And interesting enough, mate, I just add, there's that, you know, it's very rare for legislation to create an obligation to commence proceedings, but the BCCM Act actually has that, as much as that's suspended at the moment for COVID. But in normal times, a body corporate must commence legal proceedings to recover levies if they've been overdue for 2 years and 2 months. So if those things aren't being done, that would be another example.
Well said, Frank. Another example of dysfunction would be if you've got multiple groups of people calling themselves the committee. So you've got one group over here that said, we're the elected committee. Another one over here said, no, actually, we're the elected committee. And then you might have a third one that says, actually, we're the elected committee. Or if you've got different groups purporting to instruct the body corporate manager that we're the committee and therefore you do as we say.
With the people in front of Judea.
Yes, in front of Judea. Very nice, yeah. No maintenance being done at all. That's probably dysfunctional. No committee being formed is a dead giveaway that there's dysfunction, because nothing can actually literally be done without there being a committee. So if there's no committee, it is dysfunctional.
Including, in theory, even calling a general meeting to vote a committee in, because who makes the decision to do it?
That's right. Yep, there has to be a trigger point, doesn't there? And on that basis, if there's a committee formed, but they're not making decisions or they're not actually meeting, that suggests that it's dysfunctional. Funds going missing. That's a pretty obvious one, I would have thought. And then another giveaway for a dysfunctional body corporate is legal proceedings. So that's where the body corporate can't defend itself in legal proceedings or can't initiate, because simply they don't have the ability to make those decisions to get that defence happening. Do you reckon
No, mate, I'm just going to say, until we had one body corporate recently who came to us who had a judgment entered against it where proceedings had been filed, had been served, committee had done nothing, and then 60 days later, the plaintiff, just filed judgment.
Absolutely. Another one might be if a body corporate is involved in, say, the proceeding in the Land and Environment Court. That comes up from time to time, and they don't defend themselves in those proceedings. That's pretty problematic. So look, that's not an exhaustive list, but I think you get the drift. These are serious things. Basically, the business of the body corporate can't go on. That's dysfunction to me. Would you agree, Frank?
Yeah.
Yeah,
and they're not. And I suppose so. We've started with the things that it's not, the things that it are, that are, and there's obviously a myriad number of variations and themes in between those in terms of the extent and severity of some of those. So put them all in the one box. It might be bits and pieces collectively might not be. It's sort of there's a lot of context in these things, and I suppose probably, Chris, it's probably the best way to look at it is the business of the body corporate falling apart.
Yep, that's right. Yeah, a body corporate is not technically meant to be a business, but let's be honest, it is. It's the day-to-day running, it's a business. And if things aren't getting done the way they should, that's generally dysfunction. Why do you care, or why should you care? Well, there are actually some really significant consequences of dysfunction. At worst, it is life and death. So if common property is unsafe, that's a literal life and death consequence of dysfunction.
Fire safety obligations aren't complied with, pumps aren't working.
Live power, sitting around in common property, that sort of thing. Financial liability is obviously a big one. So if there's no insurance and there's then an injury, or even worse, a fatality on common property, that's pretty serious stuff.
Because I think the thing that not many people realise, and it's certainly not advertised when you buy a unit, is effectively whenever you buy a piece of unit, a lot in a body corporate, you're effectively personally liable for your proportionate share of that body corporate's liabilities. So a body corporate itself cannot be insolvent. So when companies become insolvent, they get wound up and they go to the corporate undertaker and ASIC strikes them off and all that sort of stuff. It doesn't happen in body corporates. So if there's a liability for a body corporate of $1 million, which might be a claim for something that wasn't insured for because there was no insurance, or an exclusion, or whatever it might be, each of the lot owners is liable in their respective proportions for that amount.
And that answers one of our questions. Is a substantial debt in the administrative fund indicate that the body corporate is dysfunctional? Well, there shouldn't be a debt.
Admin fund should never be a negative.
No, it shouldn't be. So yeah, that suggests a problem, definitely. Some of the other consequences are criminal charges, criminal issues, legal proceedings where people might end up being personally liable.
And that's probably the question we get all the time too. Committee members, personal liability, it is a low bar. There should be insurance. There should be directors and office holders insurance for committee members. There is a protection in the legislation for acts taken in good faith and without negligence from personal liability. But acts of sheer stupidity for which the insurance might disclaim, or if there is no insurance, you might not be covered. So as much as we get asked that question a lot, but a lot of the times we get asked the question about committee liability, it's for something that really doesn't occasion a lot of financial harm to people because there's been a decision made that, again, people might not have agreed with, but the body corporate still spent the money on something that was a body corporate asset. So in that sense, there's not a real loss to individual owners, but there is a degree of risk if you just stick your head in the sand and hope all this stuff goes away and you're on a committee.
Well, I mean, there's more to it than that as well. I mean, there are the intangibles of stress and anxiety and conflict. The other big thing that might be a consequence of dysfunction is actually it affects your hip pocket because the value of your investment will plummet under all of those circumstances. Your ability to sell, it would be non-existent in some of those cases that we just described. So we've spent a lot of time talking about what it's not and what it is and what the consequences are. Let's talk a little bit now about what you can do about it. And we'll start with what you can do about it now, or what protections are offered now under the legislation. And there are two main ones that the Body Corporate and Community Management Act in Queensland offers. The first one is what's called a Part 5 agreement, and that's where a committee doesn't get formed as it should, and the body corporate manager takes on the role of the committee. I think it's fair to say, Frank, that there's probably a number of buildings in Queensland that probably need a Part 5 agreement, but don't have one. And things are moving along in a very loose arrangement.
Yes, which is all fun and games until someone loses an eye. So they're going to mix metaphors again. Yeah, mate, I think it's back, if a tree falls in the forest and no one hears it, does it make a noise? And I think that's the same with bodies corporates. I mean, we've got 50-odd thousand strata schemes in Queensland. Without doubt, there are lots of them that are not complying with their statutory obligations around committee minutes and all that sort of stuff. And because no one is blowing up, it's not sort of seen to be dysfunctional, but that doesn't mean that people aren't necessarily accruing risk by not running the thing the right way.
Yep, definitely. The second way in which the legislation offers assistance at the moment, and one which I think is probably most relevant for this discussion, is the appointment of an administrator. So let's be clear, we're not talking about an administrator in the financial sense where a company goes bust and then somebody is brought in to help the company trade out of it. That's not what an administrator is in this context. An administrator in this context is where somebody applies to the Commissioner's office, my old office, for an adjudicator to order that an administrator get appointed. The administrator does not have to have any particular qualifications. Often it's a body corporate manager, but it can actually be a lot owner.
It could even be a former commissioner for body corporate and community management, couldn't it?
Who would do such a thing? I don't know anybody like that. Basically, the job of an administrator is to get things right again. So if you're saying to me things are really difficult, an administrator comes in, calls a meeting, makes decisions, gets things back on the straight and narrow. Well, that's what they're meant to do. It's a really serious step to appoint an administrator, and the reason why it's a serious step is because once an administrator is appointed, all of the owners lose their rights. So if you're an owner in the scheme and an administrator gets appointed, you don't have a vote for the period of time that administrator's there. The administrator makes all the decisions. So again, I used to see it all the time. People would come and say, I want an administrator appointed. And then when you told them that, they thought about it much more carefully than that. But even so, Frank, there are many instances where an administrator is absolutely required, isn't it?
Absolutely. And I suppose over time, they can be appointed wholesale or they could be appointed for specific purposes, you know. So one of the memorable ones we had was where a body corporate wasn't complying with the statutory obligations in relation to the maintenance and repair of the roof, simply ignoring continual leaks and all that sort of thing. So we acted for a lot owner to have an administrator appointed who was effectively a project manager to actually go and replace the roof. And part of that program then was striking the special levies on all of the owners for that work and following through the payment of them. So in relation to that particular project, that's what the administrator did.
And it can be that specific, can't it? It doesn't mean that the administrator goes in there and just turns everything upside down. It can be that specific. The process of applying for an administrator, same as anything for the Commissioner's office, you put in an application. It goes the same way as other applications too, and that means that other owners will get the chance to have their say. So you do need to be careful if you're thinking about applying for an administrator. Not only do you have to source the administrator yourself and get their consent to be appointed, other owners will get the chance to have their say about that, and also the person. And the other owners can put up their own preferred administrator. And then the adjudicator is going to have to decide in that case. The other thing to remember, the administrator will need to be paid out of body corporate funds. So it's not as though the Commissioner's office will pick someone. You need to do all of that work yourself. You need to put that to the Commissioner's office. More to the point, you need to demonstrate why it's actually needed, and the adjudicator needs to be convinced that they need to take that step. It's a big step to take.
It's an enormous step.
Yep. Not one taken lightly.
No.
There is a practice direction on the Commissioner's office website about that, which goes into that in a bit of detail. It's a pretty good one. Not that I wrote it or anything, but it's a pretty good one nonetheless. So for
what
me,
happens if you're in the middle ground where you're not quite in administration territory, you've got maybe a lot of fights going on, a whole bunch of issues, late night emails, reply alls everywhere, hopefully not too much defamatory stuff, which he spoke about last week, for those of you that want to go and find that link.
Nice plug.
So there you go. So what do you do then? And I suppose this, ladies and gentlemen, is one of the things that really, I suppose, has become an evolving part of Chris's involvement with our office. So before this, what would have happened is someone comes to us with I have a body corporate problem. This is my issue, and we would give them legal advice around that. So that would be a specific, whatever it is, bylaw, CCTV problem, we've got a nuisance owner, whatever it is. And what we have been doing, and I think, Chris, quite successfully with a couple of committees in recent times, is helping them see the forest for the trees, because dysfunction, in a sense, can manifest itself in any number of different ways. And as much as, hopefully I don't try to sound exceedingly arrogant here, but between Chris and myself, we have seen lots of grief in strata. Chris will have seen a lot more of it than I have in his former role as commissioner. And we see the people that come in all day, every day, I suppose, with a siege mentality, suffering some form of really, it can be significant stress, because you put your hand up to go on a committee, or you buy into a body corporate and you don't know what's going on, and then suddenly you're getting belted from pillar to post with a whole bunch of accusations, claims, demands, timeframes, to respond to things, and subject to the quality of the advice and your background experience. It's the first time you might have been exposed to any of this sort of behaviour.
That's
and
right.
that's where a lot of people have been coming to us. And I think, I suppose this is the joys of the technology piece. We have been Zooming with quite a few committees, helping them get their heads around the issues they're facing, because quite often all they've got is emails and accusations and threats. So it's like, let's stop, let's understand.
Let's untie
the knot.
Yeah,
absolutely.
We'll get into that now. I just want to address quickly some questions before I forget. Georgie, no, Commissioner's Office only gives free advice in to Queensland lots, if you've got a lot in Queensland, sorry. Question from Sue about some subsidiary scheme issues. Sue, I don't think, based upon what you've said there, that's dysfunctional. It's a problem, yes. I'm not sure if it's dysfunctional. Why does the legislation allow it to occur? It's not so much the legislation allows it to occur. There are options to do something about it provided in the legislation. You've got to want to, or a party has got to want to take one of those options. You may need some advice about that. And
one of the things, the legislation creates a committee, but it creates no obligations at all about how often they've got to meet.
That might change with new legislation, but that's how it is at the moment. And the question from 30, if bills need to be paid and the admin fund is in the negative, responsibility might fall back to owners. Yes, it might fall back to owners. Yep.
It will fall back to owners, because the money's got to come from the owners.
Someone's got to pay it. It doesn't just get plucked out of air. So back to what Frank was saying about what we do with it. I think the very first step comes with a bit of straight talking about what the situation is. You need to be asking yourself, is this just a series of irritations and problems, or is this dysfunction? You need to be honest with yourself about that. There's no point going along and finding an administrator if actually it's something that can be resolved a little more simply than that. The opposite's absolutely true, though. You can't keep kidding yourself that you'll just keep chucking along with your body corporate if you haven't held a meeting for 3 years and your insurance has lapsed. That's not going to cut it. So you need to ask yourself those questions first of all. As Frank and I were just talking about, there might need to be some actual proceedings to get things right. We can obviously advise upon that. But as Frank was saying, what we've been doing is holding discussions with committees or alleged committees or people in situations to try and sort through the mess of things. So people come to us and present with a situation. We don't know what to do. It seems insurmountable. Our job is to pick our way through it and get it into bite-sized chunks. And we have been doing that, I think, pretty well so far, with quite a few buildings and schemes around the state. How does that happen? Well, we hold a Zoom meeting like this. It might go for about an hour, and it's like, right, issue one. What's the issue? And then rattle off all of the problems, and then Frank and I can say, okay, solution to that is this. Do this. Do you want us to be involved in that? Okay, we can advise you further on that if you like, or you can do it yourself. Up to you. That sort of thing. We're actually delivering things, I think, in a much more straightforward way and being quite clear with people. No, you can't do that. Yes, you can do that. It's about facilitating it. Well, it's about getting people to start thinking clearly and with thinking a bit left field on a few issues. Frank and I had a conference with a building earlier this week on a particularly contentious topic for that building. They had seemingly gone through this issue time and time and time again. We sat there and we ventured up at least 2 or 3 things that they'd never thought of before about the topic. And they're like, oh, I didn't even realize that we could do that. Well, why not? So they're going away and having a good think about that. Finally, one of the things that might be useful is a structured mediation process, which is alternative dispute resolution, in which it's a structured step-by-step process to get issues on the table, untie the knot, and most importantly of all, start getting some solutions generated from the process. Frank, what do you think there?
Getting people talking. And I think that's probably been a lot of it, and I suppose in a work context, I'm as big a victim of this as much as anyone else in terms of sending 40,000 emails a day. But when it comes to resolving, I suppose, effectively what are tightly knit community issues where people have become emotionally invested in whatever the outcome is that they were seeking, or the issue itself, and it's descended down into email warfare. It's actually getting out of that and communicating. And I think probably a couple of those meetings, particularly, Chris, we sort of just help people to start talking to each other again. It almost sounds like relationship management, and I suppose that's what it is. But it's sort of helping people just understand what it is, the limitations are, where they can go, and the reality of their situation. So you're not leaving the body corporate. These people aren't leaving the body corporate either. So you can keep beating heads against this brick wall that is the system, or you can try to find a way through. So I think it's almost helping people navigate into a space which they can see an exit from.
Yeah.
And
I think, Frank, and even before that, the important step is to realise no one is going to do this for you. So if you own a lot in a body corporate and you either feel or you know that there's a serious problem going on there, let me tell you in no uncertain terms, the body corporate angel is not going to come down and cast a wand over that and make it all better. Nothing will ever change unless you take the steps to make it change. It's just how it is. Is that fair? I don't know. Maybe it's not, but that's how it is. That's just how it is. And so if you go and you say things are bad in my body corporate, there needs to be a royal commission into bodies corporate, as I've heard people say many times, my response is, okay, well, what are you actually doing about it? Well, I don't think I can do anything. There's nothing I can do about it. No, that's not true. There's always something you can do about it. It requires you to take a step. It's hard. It's really hard taking steps, isn't it, Frank?
It is. Particularly when there's no real commercial return at the end of it. You're not getting paid to do it. And I suppose this is the nature of committee involvement. People do it for all sorts of reasons. And even one of my mates is a chairperson of a body corporate, went for an early morning walk the other day. He's got a 2-year lifespan left in him, and is starting to groom people to come along to replace a couple of the older positions on that committee. So in that sense, he's taking a longer term view. There's actually a plan for the building that the current committee has that they're trying to build people into. And I suppose even that in itself is pretty rare for strata. I don't think there's too many buildings that I would know of that have that sort of leadership, for want of a better phrase. And that's just the way it is. But leadership comes in all different forms, doesn't it?
That's right. If you want things to be different in your body corporate, you've got to take steps to make it different. And there are options for you to do that. You can do those yourself, or you can speak to people like ourselves, because that's all that we do day in, day out, is develop solutions to body corporate problems. That's all we do. Are we crazy for doing that? Quite possibly, but it doesn't. The point remains that all of this discussion today, these sound like really unpleasant, difficult topics, and they are unpleasant, difficult topics. But remember, this is your investment in your home that we're talking about. Or if it's not your home, it's the amount of money you've poured into a contract, or it's the time and the connection that you have to your body corporate. Are you just going to let that fritter away because you can't take those steps to do something about it? I hope you don't. I hope not. I hope not.
No, agree. But it does take effort. And the reality is someone's got to do it. And if no one does it, then, and I mean, how many times have we had the conversation with people coming to us and want to contest what actually happened at a general meeting in terms of a particular resolution, and they haven't even bothered to vote? You know, the first question from an adjudicator is, well, why didn't you even vote against the thing you're now complaining about? It's just that apathy, and it can be annoying, I suppose, carrying what you see as a burden to fix the problems for a group of people where you're the only one putting your hand up. But the alternative, sell and get out, accept the reality and do nothing. Doing nothing is a choice, but then you probably do lose the right to whinge about the outcome because you had a chance to do something about it and you didn't.
Oh, I think you absolutely lose the right.
There's a bit of straight talking, and that's just the reality of it. So
don't, what's that? Don't come crawling to me when it all goes wrong. You have to be able to show that you've tried your best. So I suppose, in conclusion today, the key messages: there's problem, and then there's dysfunction. Dysfunction requires a bit of a higher level of intervention, I think. Problems, that might also involve some intervention, but there's probably a lot more things you can do about that.
It starts with owning the solution, doesn't it?
It does. And in that regard, get in touch with us. If you've got a problem in your body corporate, get in touch with us, because we take a very tailored approach to creating a solution. No two buildings are the same. No two bodies corporate are the same. So, of course, no two answers are the same. Just a quick note, if you've got specific queries or specific follow-up from today, your best bet is to drop us an email so that one of the team can get back to you. info@hyneslegal.com.au is your best bet, because you won't necessarily get the answer you're looking for by putting a post on our Facebook page. It's always better that we can talk to you one-on-one. With that, Frank, I think we've come just about to the end of today. Yeah.
I don't know how these half hours disappear. It seems like we only started talking 2 seconds ago.
Yep. No, I agree. That one flew by. Makes me wonder if perhaps we need to revisit dysfunction part 2, and we'll give that one some thought.
Yes.
We don't give away our topics at the end of the webinar, but we'll give that one a little bit of thought. Don't forget, Fridays, 2 o'clock, webinar. Like and share our Facebook page, and then that way you can find out what the topic is and get reminders. The link for next week's webinar, where you can actually register to be reminded, is now up on our Facebook page. So make sure you do that and make sure you tune in. With that, Frank, as always,
have a good weekend, everyone.
And thank you, everyone, for taking the time to join. We really appreciate it.
Absolutely. Thank you.
See you next week.